This presentation will cover Chapter 7, Arrest, Search Incident to Arrest, and Protective Sweeps. An arrest is not specifically named in the Bill of Rights. However, it is interpretively talked about when you look at the Fourth Amendment, where it says that that you must particularly describe the place to be searched and the persons or things to be seized. So when you seize a person, that is an arrest. And you shall not, according to the Fourth Amendment, you shall not be violated. No warrant shall be issued but upon probable cause, supported by oath or affirmation. So that's where we get the probable cause to make an arrest. The basic elements necessary for a formal arrest include law enforcement officer's purposes or intention to take the person into custody. So, to make an arrest, you have to want to make an arrest. The officers exercise a real or pretended authority. That the arrestee be taken into custody either by physical force or by submission to the assertion of authority. And the vast majority of arrests are going to be by the submission. You normally, when you take the handcuffs out, they submit to the arrest. You don't have to fight the majority of people. That's the exception to the rule. And then understanding by the person to be arrested of the officer's intentions to arrest. So it also includes the person that has to be arrested to be a formal arrest. To the best of their ability, should realize they're being arrested. A seizure of a person that is substantially indistinguishable from a formal arrest is illegal unless it is supported by probable cause to believe that a person is committed or is committing a crime. And this is the difference between a stop and arrest. Is to stop someone, you need reasonable suspicion. When you formally arrest them, then you need probable cause. When your arrest is made under the authority of the warrant, that is the preferred method from the courts, because you've had a neutral party determine that there was probable cause. When you give the affidavit to the judge, he looks at it and says either there's probable cause, and he signs the warrant, or he says you don't have enough, go back and get me more probable cause. The arrest warrant protects the officer in an important way. If a warrant is proper on its face and the officer does not abuse his authority to obtain or executing the warrant, they have qualified immunity against civil liability for damages, even though the warrant is later determined to be invalid. So as it turns out, the courts later interpreted that you don't have the probable cause, or that the judge erred in saying you have probable cause. The arrested person can't then and there go sue the officer. An arrest warrant is a written order to arrest a person issued by a proper judicial authority on the basis of a sworn complaint or affidavit charging the commission of a crime, supported by a statement of facts and circumstances establishing the probable cause. And you're just going to have all the elements of the crime in there to help establish the probable cause. Summons is similar to warrant, except it directs the person to appear in court rather than ordering the person's arrest. Normally you're going to have summonses in lower level misdemeanor cases. You send them a summons to show up in court. If they don't show up in court, then the judge will usually issue a warrant to arrest them for not showing up. But you'll often have summonses in type of code enforcement cases and some other municipal court cases. Warrantless arrests are allowed. The Fourth Amendment permits a warrant arrest in a public place under certain circumstances. Generally, the authority to arrest without a warrant depends on the difference between a felony and misdemeanor. With a felony being a more serious offense, obviously there's more leeway in arresting somebody for a felony than for a misdemeanor. In most jurisdictions, a law enforcement officer may make a warrantless public arrest for a felony if at the time of the arrest the officer has probable cause to believe that a felony has been committed and that the person arrested is committing or has committed the felony and has recently committed the felony. Just because you have probable cause to arrest somebody for a felony, that doesn't mean you can arrest them 2 weeks later. It's got to be, there's some immediacy to it. A warrantless arrest for a misdemeanor may be made only when the misdemeanor is committed in the officer's presence, unless otherwise provided by a statute or by the state's constitution. All five senses may be used to help satisfy the in the officer's presence requirement. So the crime could have happened within eyesight of the officer. It could have happened within earshot of the officer, or it could happen within the smell of the officer, or even within the touch of the officer. You know, if you can't see but you can feel it, that still counts as within your presence. Certain devices that enhance the senses may also meet this requirement. Night vision, in a limited type case, you can use your, well, let's face it, eyeglasses or an enhancement to your vision. Wearing a hearing aid is an enhancement to your hearing. You can't necessarily use a parabolic dish to listen to somebody talking in their private home, but you can use your hearing aid to hear what they're saying, and that is still permissible. The arrest should be made as without unnecessary delay. So if you're going to arrest somebody without the warrant, you have to do it right when you have the original probable cause. If you're going to wait, then you're going to need the warrant. In Texas, Chapter 14 of the Code of Criminal Procedure covers the arrest without a warrant. We'll start first with offenses within a view. A peace officer may, or any person may, without a warrant, arrest an offender when the offense is committed in the presence or within his view if the offense is one classed as a felony or as an offense against the public peace. Now, what are public peace crimes? Public intoxication, possibly disorderly conduct, those type things that are going to have a breach of the peace. A peace officer may arrest an offender without a warrant for any offense committed in his presence or within his view. So a private citizen can make an arrest in a felony, a citizen's arrest, but not in a misdemeanor case unless it's a breach of the peace. Within the view of a magistrate, a peace officer may arrest without a warrant when a felony or breach of the peace has been committed in the presence or within the view of the magistrate, and such magistrate verbally orders the arrest of the offender. So if the judge sees it, he can order your arrest. You don't need affidavits. He can just order you to arrest somebody. Any peace officer may arrest without a warrant persons found in suspicious place and under circumstances which reasonably show that such person have been guilty of some felony, violation of Title IX, Chapter 42 of the Penal Code, breach of the peace or offense under 4902 of the Penal Code, or threaten or about to commit some offenses under the laws. And again, we're talking about disorderly conduct, public intoxication, and some kind of a threat to commit an offense. And a person who is a peace officer has probable cause to believe have committed an assault resulting in bodily injury to another person, and the peace officer has probable cause to believe that there is danger of further bodily injury to that person. So if someone beats somebody up, you didn't see it happen, it's still a misdemeanor, but you fear that it's not over, that there will be continued violence, you can arrest without a warrant, even though you didn't witness it, and even though it's a misdemeanor. A person who is a peace officer has probable cause to believe have an offense defined under 2507 of the Penal Code, which is violation of protective order or violation of protective order issued on the basis of a sexual assault if the offense is not committed in front of the officer. So if someone's breaking a protective order, even though you didn't see them breaking it, you still have probable cause. You can make an arrest without a warrant. And a person who is a peace officer who has probable cause to believe have committed an offense involving family violence. So family violence is kind of a hot topic type thing, and you can make an arrest even though it wasn't in your presence. A person who is a peace officer who has probable cause to believe have prevented or interfered with the individual's ability to place a phone call in an emergency if the offense is not committed in the peace officer's presence. And that's usually one that's not going to be in your presence. That's where they pull the phone out of the wall. Of course, that doesn't happen too much today, because how many people still have a phone in the wall? But you take your cell phone and you crush it. That type thing. You do not need a warrant to make the arrest in that case either. And a person who makes a statement to a peace officer that would be admissible against the person and establishes probable cause to believe the person has committed the offense. So when someone confesses to a crime, to a felony crime, you can make an arrest without getting a warrant. This is a relatively new law. I remember when it went into effect, it was pretty good. We would then, if someone confessed, we'd just put them in jail and not have to worry about the warrant. Now, with that said, the way I worked, if I would bring them in to question them, and I told them that I will not arrest you when you leave. When we're done today, you can go home. I'm not saying I won't arrest you in the future, but I'll give you time to, to make arrangements for bail or bond before I talk to them, or and I will definitely let them leave at the end of the day. It's a situation where I don't make that promise, then I'll arrest them and get it over with. It's a little bit quicker. Now, this is a really important one because it's not just may make arrest. It says a peace officer shall arrest without a warrant a person the peace officer has probable cause to believe committed an offense under 2507, violation of a protective order, or the violation of a protective order on the basis of sexual assault if the offense is committed in the presence of the officer. So you may make the arrest if it's not committed in your presence, but you shall make the arrest if it is committed in your presence. That's one of the few times where you're mandated to make an arrest. If reasonably necessary to verify an allegation of a violation of a protective order or the commission of an offense involving felony violence, a peace officer shall remain at the scene of the investigation to verify the allegation and to prevent further commission of violations of family violence. So while you're trying to verify whether it was there, you shall remain at the scene. It's not a you may remain at the scene. You shall remain at the scene. A peace officer who is outside his jurisdiction may arrest without a warrant a person who commits an offense within the officer's presence or view if the offense is a felony, a violation of Chapter 42, which is disorderly conduct, or 49, which is intoxicated or alcoholic beverage offenses, public intoxication, or a breach of the peace. So if you're a peace officer, you can make a arrest outside your jurisdiction for felonies or pretty much breaches of the peace. A peace officer making an arrest under this subsection shall, as soon as practicable, after making the arrest, notify a law enforcement agency having jurisdiction where the arrest was made. The law enforcement agency shall then take custody of the person committing the offense and take the person before a magistrate. So when you arrest somebody outside your jurisdiction, you have to turn it over to turn the suspect over to somebody who does have jurisdiction where the arrest was made. Now, when a felony is committed, in 1404 it says, where it is shown by satisfactory proof to a peace officer upon representation of a credible person that a felony has been committed and that the offender is about to escape so that there is no time to produce a warrant, such peace officer may, without a warrant, pursue and arrest the accused. This is going to be a rather common situation. It's where you're investigating a case, could be a shooting, stabbing, something of that sort, and the witnesses at the scene tell you that John Doe did it. You could pursue him and arrest him without a warrant because you may not be able to find John Doe again in the future. And now, as far as police officers from other states, a peace officer commissioned and authorized by another state to make arrests for felonies who is in fresh pursuit of a person for the purpose of arresting that person for a felony may continue the pursuit into this state and arrest the person. This section, the fresh pursuit means a pursuit without unreasonable delay by a peace officer of a person the officer reasonably suspects has committed a felony. So if you're chasing somebody, you're a peace officer in Louisiana and you're chasing a guy down I-10 and he goes across the Sabine River, you can keep on chasing him as long as you're chasing him for a felony. In general, a private citizen may make a valid citizen's arrest, but it must be based on probable cause, and the private citizen may use a reasonable degree of force when making an arrest. But the private citizen who is mistaken when they make a citizen's arrest may be held civilly liable for damages, so you have to be real careful. And anytime you have a security officer or store detective or anything like that, anybody like that making a arrest, they're actually making a citizen's arrest because security guards do not have arrest powers any different than a private citizen. Well, here in Texas, you can make a citizen's arrest when the citizen has probable cause to believe an offense is being committed in his or her presence or view, and the offense is one of uh, classed as a felony or a breach of the peace. Such as again public intoxication, disorderly conduct, driving while intoxicated. Or the second way is to prevent the consequences of theft by seizing any personal property which has been stolen and bringing it with the offender, if the offender can be taken before a magistrate or peace officer for examination. To justify the seizure under 2, there must be reasonable ground to believe that the property is stolen and the seizure openly made and the proceedings conducted without delay. This is how you can, stores can arrest people for shoplifting. Generally speaking, it's not going to rise to the degree of a felony. It's not a breach of the peace, but it is, is a theft, and you can stop the person, recover your property, and take them to a peace officer. Okay, some of the provisions for arrest. Unless there's an extenuating circumstances, also arresting a person should give notice that the person is under arrest, as well as notice of the officer's authority and the cause of the arrest. Your authority pretty apparent when you're in uniform and you're on a call, but especially if you're a plainclothes officer, it's always good to identify yourself and advise them they're under arrest. An arrest with or without a warrant may be made on any day of the week and at any time of the day or night, unless otherwise provided in the warrant or by the statute. And here in Texas, there is no time frame for our warrants. Absent exigent circumstances or consent, a law enforcement officer may not make a warrantless entry into a suspect or a third party's home to make a routine felony arrest. And again, this is in general, not in Texas. We can make entry on a felony, but you have to know the person's in the house. When arrest would create a great risk to public harm or would cause an embarrassment to a person who poses no real threat to the community, proper police practice may call for delay or restraint in exercising the power of arrest. There's no law against arresting someone as they're walking down the aisle to get married, but if you're arresting them for a traffic offense, that would not sit very well with the public. So you got to use your little bit of restraint. Now, on the other hand, if the guy walking down the aisle is a serial rapist or serial murderer, then it might not be a bad idea to make the arrest even at the wedding, because uh, you know, the seriousness of the situation. Here in Texas, Code of Criminal Procedures 1522 says when a person can be arrested. A person is arrested when he has been actually placed under restraint or taken into custody by an officer or person executing a warrant of arrest, or by an officer or person arresting without a warrant. Arrest may be made at any time or any day or any time of the day or night. In making an arrest, all reasonable means are permitted to be used to effect it. No greater force, however, shall be resorted to than is necessary to secure the arrest and detention of the accused. So you cannot use any more force than is necessary to make the arrest. In the case of a felony, the officer may break down the door of any house for the purpose of making an arrest if he be refused admittance after giving notice of his authority and purpose. Like I say, you got to be pretty sure the guy is in there before you go kicking doors in. But you knock on the door, you tell them the police, you hear the pitter patter of feet on the floor, you've got pretty good reason that you can go ahead and kick the door in. Authority to arrest must be made known. In executing a warrant of arrest, it shall always be made known to the accused under what authority the arrest is made. The warrant shall be executed by the arrest of the defendant. The officer need not have the warrant in his possession at the time of the arrest, provided the warrant was issued under provisions of this code, but upon request he shall show the warrant to the defendant as soon as possible. I mean, when we're making warrant arrests for other agencies all the time, we don't have a copy of the warrant. It's all done through computer hits, and you don't have to physically have that warrant. But they can demand to see it. They're going to have to wait till they get to the police station where it's at, though, if we arrest them from another agency. I never, very rarely, kept my warrants with me. If I had a warrant for someone's arrest, I'd leave it at the station and go from there because it was there. Now, when you get him booked in, if he wants to see the warrant, that's fine. We can produce it at the police station. The procedure for executing a warrant: officers are simply required to carry out the command on the warrant. The only questions of concern are whether the person to be arrested is the person identified in the warrant. And sometimes this can be a very complicated question. Quite often, you'll have cases where people claim that they're not the person named in the warrant. Most of the time, they are. Sometimes they're really not. Sometimes the warrant was issued in error for them. Particularly could be a case of identity theft. It's kind of common for traffic offenses for brothers or sisters to use their brother or sister's names and date of birth because, hey, you know your family's name and date of birth. So that is possible. So you got to make an effort to make sure you're arresting the right person. And you got to make sure the warrant's valid on face. Make sure the judge actually signed it. I've got warrants where got back to the station, they weren't properly signed, and had warrants where we've had mistypes, typographical errors, and you have to go back and get them all corrected. An arrest warrant is valid on its face if one or more of the following is true. The court issuing it is it's invalid if the court issuing it clearly has no jurisdiction. It fails to adequately indicate the crime charge. It fails to name or describe any identifiable person. And then you can actually get a John Doe warrant if you don't know the person's name, if you can adequately describe the individual to the degree where you could say that is for sure who it is. I've never had one and never known anybody to, but it is possible. It's not signed by the issuing magistrate. It is directed to the officer. It is not directed to the officer who is about to execute it. The final one does not apply in Texas because warrants are made to any peace officer, to the sheriff or any peace officer in the state of Texas. So we're pretty well covered on that as long as you are a peace officer in Texas. Extenuating circumstances. Courts have established several categories of exigent circumstances that have been held to authorize law enforcement to officers' warrantless entry into a home. One is the risk that evidence is being destroyed, or when you're in a hot pursuit of a felon, threat to the safety of the suspect or others, or the likelihood that the suspect will flee and therefore escape. So those would be exigent circumstances that would allow you to make forced entry. Of course, just knowing they're in the house with a felony warrant in Texas is good enough here in Texas. A little bit different than some other states. And absent extenuating circumstances before law enforcement officer may lawfully force their way into a dwelling to arrest someone inside, they should first knock on the door, announce their authority and purpose, and then demand admittance and be refused admittance. Again, this would follow Texas law. You have to knock and announce and let them know you're there. Law enforcement officers may arrest outside their jurisdiction in hot or fresh pursuit, which we already talked about in Texas. Even an out-of-state law enforcement officer can arrest somebody in Texas if they're in hot pursuit. Once you arrest somebody, you have to make a return on your warrant. which includes completing information, date, time, where the arrest, at arrest location, so forth. The officer executing the warrant must make the return. The return is made by entering the warrant, the date of the arrest, signing the warrant, filling out the warrant with, or filing the warrant with the court. And failure to return an arrest warrant may invalidate the arrest and subject the officer to civil liability. Most departments have a procedure. You simply sign the warrant and put it in a box, and it mysteriously finds its way back to court. They'll get sent through inter-department mail to the actually issuing court, usually within a week of the arrest. The use of force in making arrests. The basic rule covering the use of force while making an arrest is that law enforcement personnel may use whichever force is necessary to make the arrest, but not use excessive force, which, if you remember right, follows Texas law pretty much to the word. Use of force is judged under a total situation, under the Graham's balancing test. Deadly force may only be used by law enforcement officers, 1, in defense of their own lives, 2, in defense of the lives of others, or 3, to stop the escape of a fleeing suspect if there is probable cause to believe the suspect has committed a crime involving the infliction or threatened infliction of physical harm. It's going to be very difficult to shoot somebody who is running away from you and hold it justifiable unless they are actually going to cause you harm. I can see a case maybe where you could argue that a serial killer that could escape could continue to kill somebody and therefore would be a risk to life, but I sure wouldn't want to be one that tried to get up in court and say that's the reason I shot someone running away from me. And it's a little different when someone's escaping from prison, because they have a little bit different set of rules that the prison guards fall under. Now, part of the arrest includes the booking process, and that is the administrative procedure where you actually bring the person to the station. You get their name, the arrest information, location of arrest. You'll take the mug shot. You'll take fingerprints so that you can identify who the person is. In case they use a false name, this is a very important step. And then you put them in a temporary holding cell while they await seeing the judge, bonding themselves out, or await transfer to a different jail. And the initial appearance usually occurs within 24 to 48 hours. And after arresting a person with or without a warrant, you must take the person before a magistrate or deliver the person according to the mandate of the warrant. Statutes are different in different states. Here in Texas, on felonies, you have 48 hours. And it's often that instead of bringing them to the judge comes to them. Because you've got a lot of prisoners in there. You'll have city judges that will come into the city jail and magistrate all the prisoners in the jail at once. In Texas, the duties of the arresting officer and the magistrate are defined in the Code of Criminal Procedures 15.17. In each case enumerated in this code, the person making the arrest or the person having custody of the person shall without unnecessary delay, but no later than 48 hours after the person is arrested, take the person arrested or have him taken before a magistrate of the county where the accused was arrested, or to provide more expeditiously to the persons arrested the warning described by the articles before a magistrate in any other county of the state. Now, this can be important, and if you work in a city like Friendswood, which is in 2 different counties, you don't have to bring your prisoner to Harris County if you caught him on the Harris County side, or Galveston County if you caught him on the Galveston County side. Make it expeditious so you can have one magistrate everybody. The arrested person may be taken before the magistrate in person, or the image of the arrested person may be presented to the magistrate by means of electronic broadcast. Then this means you can do it by telecommunication, basically Skype them to the judge. They do this a lot in larger counties like Harris County, where they'll The judge will be in one location. They can magistrate people at jails all over the county. Duties, again, continued duties of the arresting officer. The magistrate shall inform the person arrested of the accusation against him, of any affidavit filed therewith, of his right to retain counsel, of his right to remain silent, of his right to have the attorney presiding during any interview with peace officers or attorneys representing the state, of his right to terminate the interview at any time, and of his right to have an examining trial. Most of these kind of fall into the Miranda warnings. The right to remain silent, have an attorney, and have one appointed, all fit in with Miranda. The magistrate shall also inform the person arrested of the person's right to request the appointment of counsel if they cannot afford one, and the magistrate shall inform the person arrested of the procedures for requesting appointed counsel. Pretty much they'll get the ball rolling. They'll have some paperwork for them to complete and forward it on to the powers that may be so that they can get one appointed. A law enforcement officer may monitor the movements of an arrested person as judgment dictates to ensure the officer's safety and arrest integrity. Once a person is lawfully arrested in custody, police may search the person and any containers or item in his possession. It's an inventory research. It's incident to a lawful arrest, so it's an exception to the warrant rule. Arrested person may be subjected to various identification and examination procedures. Reasonable force may be used for this purpose. The one time I had a complete FBI investigation launched against me and a couple other officers was when we were trying to take the fingerprints of a guy who had tried to kill a police officer, charged with attempted capital murder of a police officer, and he refused to be fingerprinted. We left him overnight. Still couldn't get fingerprints from him. We sent him to the county jail. It was under an order not to bond out. I went over to the county the next day, and we fought him for his fingerprints. We finally got him to open up his hands. We got a kit that you use to take fingerprints from a deceased that has a little spoon on it, and we would one officer would wrap him on the knuckles with the wheel from a typewriter, and every time he whacked him, he'd open up his hand, we'd grab it, we'd get that fingerprint. We had to do it 10 different times. He didn't complain, but one of his relatives complained about how we did it. We were exonerated. We were doing the lawful process. We needed his fingerprints because that's the way we show who was arrested. Well, if you do make an illegal arrest, that doesn't negate the jurisdiction to try the person for the crime. There may be some civil liabilities, but it doesn't keep them from facing the charge. You may have evidence that you cannot use that stemmed from the arrest, and without that evidence, it's often impossible to get a conviction. But if you did have some independent evidence that wasn't illegally obtained by the illegal arrest, then the illegal arrest would not keep you from prosecuting somebody. As you know, you normally need a warrant before you search somebody or search their belongings. But because of the nature of an arrest, it would often be impossible to get a warrant in time to search that person or their property. Therefore, there is a exception to the arrest warrant procedure that allows you to search someone incident to arrest. One of the most important exceptions can be found, or court decisions on this can be found in Schimmel versus California, regarding the searches incident to arrest. And when the arrest is made, the courts held that it is reasonable for the arresting officers to search the person arrested and the area within his immediate control, the area from within which the person might gain possession of a weapon or destructible evidence. So pretty much anywhere where they can leap out and grab, you can search. Now, if it's locked, then that wouldn't be something they could immediately get into. So if it's in a locked box that they can reach, you can't search the box inside the box. You could seize the box if the box was evidence, but not inside of it. To justify a full search incident arrest, there first must be a lawful custodial arrest. It involves taking the person into custody and transporting him or her to the police station or other place to be dealt with in accordance to the law. So it kind of pulls out the traffic offense where you're actually going to write them a ticket and let them go. You've kind of arrested them by stopping them from going for a crime, but it's only a temporary stop. Custodial arrest for minor crimes do justify a search incident arrest. So if you were putting them in custody for, say, driving without a license, you could then search them in their immediate area. But if you're going to write them a ticket for driving without a license, you can't. A valid search incident to a lawful arrest allows for seizure of the items that you find. Contemporaneous, in general, a search incident to arrest must be contemporaneous to the arrest, which means at the same time probable cause of the arrest developed or shortly thereafter. So you can't make a search incident to arrest an hour after you've brought somebody to the jail. If a delay between the arrest and search becomes prolonged, the officer must be prepared to provide good reason for the delay. A search incident to arrest may not both precede an arrest or serve as part of the arrest justification unless probable cause exists to arrest existed before the search. So you can't make it an incident to arrest if you search the guy and find drugs and then arrest him. That would be prior to the arrest. Now, if you've got probable cause to arrest him for, you can have a marijuana cigarette sticking out of his mouth, and then you search him and find cocaine, then that would be incident to the lawful arrest for the marijuana, and you could then charge him with the cocaine. You wouldn't necessarily have to charge him with the marijuana charge to have it as a lawful arrest. The allowable purpose for the search incident to arrest are to search for and remove weapons that the arrestee might use to resist arrest or effectuate an escape, or to search for and seize evidence to prevent its concealment or destruction. A law enforcement officer may conduct a full search of a person's body incident to the arrest of the person, and it may include an internal body search. A search incident to a lawful arrest may also extend to areas within the immediate control of the suspect. Sometimes it's referred to as the arm span, wingspan, lunge area, wing spread, or grabbing distance. So pretty much anywhere they can leap and grab something rather quickly. Now, the search of containers, a search incident to a lawful arrest may extend to all items and containers within the arrestee's reach. Any evidence found within the area may be seized. If, however, police seize luggage or other personal property not immediately associated with the person of the arrestee, they may not conduct a delayed search of the property if it has come within their exclusive control without a warrant or exigent circumstances. So you can't bring the purse and or the suitcase or to the station and then search it later on. You'd have to have reason to do it right there at the scene. When law enforcement officer has made a lawful custodial arrest of either an occupant or recent occupant of the vehicle, the officer may contemporaneously search the passenger compartment of the vehicle and may also examine the contents of any container found within the passenger compartment, whether the containers are opened or closed. Again, an unlocked container is different than a locked container. A law enforcement officer may conduct a frisk of an arrestee's companion in the immediate area of the arrest when the arresting officer reasonably believes that the companion is armed and dangerous. When you're stopping people, and this is mostly going to come up in drug cases, you always kind of assume that their buddies are also potential suspects, and for safety you're going to search them too. And it's possible the arresting officer should conduct the search. It should be at the time of the arrest or shortly thereafter, and it doesn't necessarily have to be one of the actual officer who says you're under arrest. It can be anybody in the arrest team that is there. If the arresting officer transfers an arrested person to the custody of another, the second officer may again search the arrested person for purpose of protecting this officer's safety. Not only can he, most department policies required that he be searched every time he's handed from one person to another. So you pick up a prisoner for, Alvin PD stops a prisoner who's wanted in Santa Fe. The Alvin officer searches the guy, puts him in his car, drives to the county line. Santa Fe PD comes there, picks him up, pulls the guy out of the car, searches him again, puts him in the back of his car, brings him to the city jail. They pull him out, put him in the jail, and then the jailer searches him. So you could be searched 3 times on a very simple arrest while being transferred from one person to the other. Law enforcement officer searching a person incident to an arrest may use the degree force reasonable and necessary, but no more than reasonable and necessary, to protect themselves, to prevent escape, or to prevent the destruction or concealment of evidence. The U.S. Supreme Court has held that law enforcement officers may conduct a limited warrantless search of a person merely detained for investigation, which is often referred to as a limited search incident to detention, or a Terry frisk, because it came out of Terry versus Ohio, and that's with for weapons only. A protective sweep doctrine provides a limited exception to the Schimmel rule. Under this doctrine, an officer may conduct a quick and limited search of the premises incident to an arrest to protect his own safety and the safety of his others from a potential accomplice linked to the arrestee hiding out somewhere else in the house. It's amazing how often you go to arrest one wanted person and you'll find several others. I know I went one time to go. I actually had when I was working auto theft, I had the warrant division come with me to go search do an arrest warrant. We found 2 suspects hiding in the house. It was another one of those cases, pitter patter, kick the door in, find 2 people hiding downstairs. Both of them were wanted, and then find my wanted person hiding in a back bedroom upstairs. So there were 3 people in the house. All 3 were wanted. All 3 were hiding. We actually continued. The person we came to look for was the last one we found. Some courts also allow police to conduct a warrantless search of a premise incident to arrest on those premises if police believe evidence is about to be destroyed or removed. Presentations. Next week we will be looking at Chapter 8, Stops and Frisk.